Welcome to American Court Case. Like the video, share with friends, subscribe to the channel, and
So this matter is on today for a hearing on Ms. Olafade's emergency motion. And my understanding is that this case has a good bit of history. It's a fairly lengthy procedural background. But what I was most interested in, so a couple things just procedurally. Ms. Olafade filed this appropriately. We placed it onto a calendar, I think just, a few days after she filed it. We did advise her that it is the standard practice of Fulton County and myself that rather than having an ex parte hearing that I have to turn around and repeat about 5 or 6 days later, that what the court requires is that the petitioner make every effort to provide notice to the other side, understanding that probably proper service hasn't yet been made. And it does appear to, and if they, when they appear for the hearing, if no one else appears, that Ms. Olafade would have been obligated to provide documentation of her efforts to provide notice. Obviously, she was able to get notice to you, Mr. Pearson. Please understand that you can make whatever records you would like to make, but the court certainly understands that whether your client has been served or not, your client reserves all rights to substantively respond to the motion. But the purpose of today's motion is related. So here's what I wanted to get to the bottom of, and one of the reasons I was so glad that counsel for Castleberry was present is that the primary argument and concern that Ms. Olafade has raised that does rise to the level of a potential emergency is the turning off of water and power. And so let me start with my first question, Mr. Pierce, has Castleberry taken any step to turn off water and power to Ms. Olafade's unit?
I believe so, Your Honor, because there is an outstanding debt here that has not been paid. There's been no payments made on the consent order that was entered into on the magistrate court, and the declarations do reserve the right for the condo association to turn off limited common elements to the.
Okay. And I appreciate that, not making any judgment about whether that's right, wrong, or otherwise, as much as I've had this come up before where the party is basically saying that they're threatening to take that action, but sometimes that action hasn't actually been taken at that point. And so I wanted to make sure that we didn't have a whole hearing and your answer was, well, we didn't actually do that. So thank you very much. Yeah. Okay. So, Ms. Olafade, if you would like, so one more thing before I hand it over to you, and that is, I am in the middle of a motion for new trial hearing. I had set aside about 20 to 30 minutes for this hearing. And so if you can please sort of be as concise as possible, I would very much appreciate it. Of course, obviously, you are entitled to make the arguments that are necessary for your case. But also, Ms. Olafade, please understand, to save you some time, I have read the motion that you filed. I have independently reviewed the court's docket, both the Superior Court of Fulton County and the Magistrate Court of Fulton County. So I am informed, not about the substance of the case, but informed that there is a procedural history. And I have also briefly reviewed the supporting exhibits that you provided that would provide evidence of the thing that Mr. Pierce has now acknowledged, which is that power and water have been cut off to that unit. If you would please take it from there, Ms. Olafade.
Yes, Your Honor. Thank you for seeing and hearing this matter today. So as you already established, I'm seeking immediate injunctive relief, so requiring the restoration of water and full electrical service to my unit. I'm going to get straight to the point here. So in an exhibit I did provide to you and you have already reviewed, Your Honor, you have the consent order and settlement agreement. Along with that, I provided another exhibit B to show that I have been making payments on this order. I've made a total of $4,650 worth of payments. I made the lump sum payment that was required after the hearing. as soon as I signed the agreement, I made a payment, and I have been making payments. And to date, I'm at $4,650 that has been made against this order. So on May 21st, a notice was slid under my door, and I provided a copy of that, which you may have seen, Your Honor, as well. That was slid under my door. As you can see, there is no name, no further information. It just states that utilities will be shut off on May 28th, according to that notice. So I included that for you. Immediately after receiving the notice, I contacted the board and requested clarification, copies of any judgments that are relevant here, and just an explanation of the authority being relied upon for this, but just to take meaningful steps to resolve it. And you will also note in my communications, I provided the full email thread. And a phone call was made to Thrift McLemore, I believe is the name of the counsel for the association. So I've made repeated attempts, and I've not received any response, Your Honor, but you can follow that thread for that. But from June 1st until now, which is June 16th, our water has been off in our home, electrical services as well. And electrical services are not provided by the condominium association. We pay that independently, so I'm not even sure how that is in this matter. But we have two small children.
So hang on, let me back up and ask you about that, Ms. Olafade.
Yes.
So I'm familiar generally with, condo buildings and that sort of stuff might have one central water, and it's either separately metered by the owner or it is just included in the rent. I think that must be what's happening here, but I do think I understood you to just say that you separately contract with is it Georgia Power?
That is correct. With Georgia Power, we pay that independently. It's not provided by the condo.
Okay, and have you been in touch with Georgia Power about why they turned off your power?
Yes, and they informed us that it must have been done by someone at the building, and that we asked, could they still come out, and did they have authority, and they did not, without us calling the police. So yes, Judge, we did.
Understood. Okay. One other question I have, Ms. Olafade, and forgive me if I should know this answer, but I don't see it readily. And that is, I'm familiar with the consent final order, but this all arose from a failure to pay assessment. And so one question I have is, are you otherwise current with your obligations to Castleberry, separate and apart from this consent order, in terms of if there's any current assessment, you're paying it?
Yes, I have been paying, Your Honor. I did in the ledger that I provided. I do acknowledge that there is 1 month to make up between when the order was signed and today.
Mm-hmm.
So but otherwise, yes, Your Honor. So I hope that answers your question.
It does. Thank you. And please continue. I just interrupted to ask those two questions.
Yes, thank you. But essentially, yeah, I think I've covered most things. The association, again, I have been reaching out since June 1st to resolve the matter, because I'm also unsure, is this related to a payment matter, or I'm not, because I have been paying. So I've reached out, but unfortunately, we have not received any response after repeated communications. I've even gotten an attorney to try to do negotiation and demand letter. So we are here because we're, again, on the 16th day, still have not received a response. The conditions are pretty much uninhabitable in this home, and we have two children, two very small children here. If we had received a response, I don't think we would need to be here today, Your Honor, because I've asked for the reasoning. I even asserted that I would pay, and this is still, true and honest today, that we would pay whatever amount. If this was a financial issue, we'd pay whatever amount was outstanding or needed to get this rectified. And I still have not received a response, which, again, I can't even say if this is a financial issue. If I have offered to pay and rectify the situation and have not received a response. But that's all I have to present to you, Your Honor.
Understood. Mr. Pierce?
Yes, Your Honor. I mean, so I can't speak to all the factual elements that she's presenting fully because one, this was I think we received notice on Friday or Monday. It was kind of quick that we received word from the HOA that this was happening. So I don't have all my facts together on this, to be quite honest with you, Your Honor. So I don't want to misstate anything. But I will say that the governing docs do allow us to cut off any limited common element in the condominium. The limited common elements are governed by Section 6, and I believe that's A through at least C on that page under common elements. Common elements start in Section 5, and then are further defined in Section 6 of those declarations, which are in Deed Book 47158, page 144, or page 143 through 144 specifically of that deed book in the public records. But those limited common elements specifically, it serves, is listed as any utility meter serving one or more, but less than all units is assigned as a limited common element to the unit or unit so served. So that specific language reserves the HOA's right to cut off limited common element in the situation where a $750 or more is owed to the HOA.
Well, to that point, sir, let's assume for a moment that I do have some questions about how the power is structured, but certainly I would generally concede that it probably qualifies under the definition that's in the declaration. But as to this issue, assuming for a moment you have the authority, is the basis for the cutting, I guess my question is Castleberry's position that Ms. Olafate has violated the consent final order?
Currently, yes, Your Honor. The last payment we received, we did receive one this month. We did not, according to the ledger, we did not receive one in, received a partial payment, I believe, in April, following an additional payment in May, and then additional 2 more payments in May of lesser amounts. There was no payment on record for March. And then, as she stated, she did make those initial payments in January and February.
Right. So so my understanding is that the consent agreement requires Ms. Olafate to pay $750 per month, correct?
That is correct, Your Honor.
And the payment summary that I've been given is that it looks like for February, you probably get a whole 2 payments, but that total $750. And then you get the lump sum that was required.
Mm-hmm.
And then according to Ms. Olafate, you've got a $500 payment in April, and then a $375 payment in May, and then another $375 payment in May as well.
And I think there was an additional $250 in May as well, but
Okay.
I see that there was something credited back to her of that $250 on the 13th of May as well. So I don't know if that payment did not clear or what this is. I don't have, not privy to that, but
Okay.
Sorry. So I mean, right now our position is that she's $1,000 behind in payments, roughly, based on the $250 being taken back and the $750 missed in March.
Okay. Tell me about how Georgia Power, and this may be one of those facts that you're not quite, but if Ms. Olafate is required to contract directly with Georgia Power, then how does Castleberry retain the right to direct a third-party provider to turn off access to the power?
I don't believe they directed them to turn off the power. I believe Castleberry, and again, I don't know for certain. This is what I've been made aware of recently. As I believe they have access to the power meters, to the individual units through one of their common elements like utility closets, whatever it is at the facility, and they're able to turn off those power meters to the units from there. And again, that earlier, I read to you the declarations where that is considered a limited common element defined in the declarations.
Okay. Have Mr. Pierce, I understand, especially with this type of practice, that it is hard. I mean, you are getting up to speed very quickly on something at sort of the last minute, and this may not be a case that you've been involved in from day one or were involved in the underlying actions. But I guess one question I have is, have you had a chance to talk with Ms. Olafade or anyone from your firm or from the COA to speak with Ms. Olafade regarding y'all's ability to work something out? Because as I understand it, while Ms. Olafade is in fact behind, she is attempting to make payments, and otherwise, I think while making payments has some right of presence under the declaration. And so I'm just trying to figure out if she's allowed to be there. I'm not saying I'm ruling that, but let's assume for a moment that factually and legally she has some right to be present, albeit perhaps without power and water, if there's some way for us to work this out so that you don't have a situation where small children are doing without power and water. Well, what are your thoughts on that, Mr. Pierce? Have you had a chance to speak with Ms. Olafade? Are you authorized to speak with her?
I personally haven't had a chance. So the individuals that are on this that are representatives of Castleberry are Mark Buckland and Rushil Chandra from my office.
Mm-hmm.
They are more transactional HOA representatives rather than litigators. So
Yes,
they
sir.
asked me to make an appearance at the TPO hearing today. So I haven't been privy to all the communications here. I do know that what she did state was factually correct in that she did follow up with the board. And I do believe Mark Buckland, who's the partner on this one, back in the beginning of June. That was the last that I recall. I don't know to the extent that the board authorized communications for Mr. Buckland to respond to her accordingly. As with this HOA in particular, they're concerned about their costs, obviously with attorney's fees and assessing attorney's fees on their owners. So we do our due diligence there to make sure that they want us to respond and want us to be active on a particular situation. So I'm not privy to if there was a response after from the board on June 1st or not. I don't believe a response from my office was given after June 1st.
Okay. Are you authorized or in a position to speak with Ms. Olafade regarding the possibility of resolving this matter in some method that would allow Ms. Olafade to have a restoration of her power and water and would allow Castleberry to get something towards its interests? Or is Castleberry taking the position that the consent order is totally out the window now because of the underpayments?
No, Your Honor, I believe we're still willing to adhere to the consent order. I believe what they're asking is at least a partial payment by Friday of this week of the $750, which would be $375. And I think we can agree to turn on utilities by end of day tomorrow. With the promise that $375 will be paid by Friday, and then we can reset this particular hearing for 30 days out to confirm that the second payment on that $750 has been made and she'll be fully caught. That's separate from her obligations of her monthly obligations going forward in July and onwards.
Okay. Ms. Olafade, did you understand what was just outlined by Mr. Pierce in terms of what obligation you would have to make some partial payments?
Yes, Your Honor, I'm prepared to do that immediately. I would like for the service to be turned on immediately, but I can make a payment right now. That's what I've been attempting to do. But yes, Your Honor, I do understand.
Okay.
Yeah, and the only reason I say by end of day tomorrow is because I just don't know who's at the property right now, and with it being so late in the afternoon, I just don't want to. I'm going to try to get them to get it back on today, but it may be tomorrow morning before it's back on fully.
Okay. And Mr. Pierce, for my benefit and Ms. Olafade's, if you would restate the specific expectation that Castleberry has in terms of the payments. It sounds like Ms. Olafade may be in a position to just make a $750 payment. I don't know, but I want to be clear that I understand on behalf of Castleberry what payment she's expected to make in exchange for the restoration of her power and water.
Yeah, so 375 by end of day this Friday, which would be half of the 750 that's owed. And then the additional 375 that's owed on that 750 by and I believe we reset this for 30 days out, Your Honor.
Yes.
So the additional 375 to be paid by the next hearing or before the next hearing, so that I'd prefer before the next hearing, so maybe like 3 weeks, just so that we can dismiss this case and get it off the judge's docket if that's resolved at that point in time.
Okay, so what I'm looking at is that you would be expecting a payment by Friday, which is the 19th. And then what I would likely do is reset this for July the 9th, which is just over 30. Nope, actually it's just under 30 days. I could do it that next week, but that would be a little more difficult. The easier date would be the 9th. And then you could expect that and that your expectation, Castleberry's expectation would be that Ms. Hill would have made I'm sorry, not Ms. Hill, I apologize. Ms. Olafade would have made a payment, that additional 375 payment by, say, the 8th of July. Is that right?
Yeah, I'm fine with that, Your Honor.
Ms. Olafade, is that something that you believe you would be able to work with?
Yes, Your Honor. I would just like to know am I making this on the portal, and who do I need to send the proof to? Because I actually will be doing that momentarily.
Mr. Pierce?
Yeah, you can just send proof of payment to the email to Mr. Buckland and Mr. Chandra. They'll get the email, and I'm going to confirm with them after this hearing everything that's going to take place. You can pay it how you normally been paying. We get those ledgers, so that's perfectly fine.
Okay.
And Mr. Pierce, just to reiterate, I think I had heard you say that if Ms. Olafade is able to make the 750 in whatever form, but fully by July the 8th, while also maintaining compliance with other obligations under the consent agreement, then you believe that would resolve the issue and the parties could forego the need for a further hearing. Is that your understanding, Mr. Pierce?
Yeah, that is, Your Honor. I
Okay.
don't think there'd be any issues with utilities being cut off at that point.
And Ms. Olafade, do you agree?
Yes, Your Honor. Thank you.
Okay, excellent. Okay, so then what I'm going to do is we're going to issue a very brief order. Now, the fact that that might take me a day or so to get it in writing and filed into the record, do want to be clear that it takes effect right now as I am saying it. My order is that Ms. Olafade is required to make a payment of at least $375 by June the 19th, which is this Friday, based on her representation that she will be able to make that payment and that she will also make an additional payment of $375 on or before July the 8th. Castleberry agrees that no later than close of business tomorrow, they will ensure the restoration of power and water to her unit. And should that occur, and should Ms. Olafade maintain compliance with her current ongoing obligation under the consent decree and her regular assessment obligations as a member participating in the condominium association, then this case could likely be dismissed and there would be no need for a further hearing on July the 9th. Is that accurate to what both of y'all understand, Ms. Olafade?
Yes, Your Honor.
And Mr. Pierce?
Yep.
Okay.
That is, Your Honor.
Okay, so Mr. Freehoff is going to prepare an order that says that. It will be very bare bones, just so we're all clear. And then we will get it on file as soon as possible for you all. Okay?
Okay, perfect. Thank you so much.
Do you need anything else from me, Ms. Olafade?
Yes, I'm sorry, Lauren. Just one more question. If it's through the end of day tomorrow, do I contact the board attorney Pierce, or who is?
That's a great question. Hopefully not one that we will need to worry about, but I will say that Mr. Pierce, we are directly in touch with Mr. Pierce, even if you might not be. And so if you were to notify the court that Castleberry had not complied, right, then we would reach out to Mr. Pierce and ask Mr. Pierce why Castleberry had not complied with our order. So there is a way for us to do that. Mr. Pierce, should she direct that communication to?
She can direct it to Mr. Buckland, Mr. Chandra. If we want to, I can also put my email in the chat for anyone that needs it.
Okay.
If Mr. Freehoff wants to, if she wants to email Mr. Freehoff, if she feels more comfortable doing that,
Right.
and him notify me that has not happened yet, I will address it immediately. So,
And I don't expect that it will be an issue, but obviously best to have an answer just in case it is. And as well for Mr. Freehoff to ensure that if he is contacted by Ms. Olafade, that he has a way to ensure that there is not any ex parte communication.
yeah, last time this happened, I will say that we had it back on within a few hours. So I don't expect that to happen.
I fully expect that will be the case, Mr. Pierce, but better safe than sorry. Okay, well, thank you both for being efficient and for coming up with a reasonable resolution. We will get an order on file for you as quickly as we can, and hopefully I will not need to see you all again, but we are here if something comes up that requires court involvement.
Welcome to American Court Case. Like the video, share with friends, subscribe to the channel,